Ladies and gentlemen, I am Sudeep Malik, partner at Khaitan and Company's construction and real estate practice. I extend a very warm welcome to each one of you in India and around the world from wherever you are watching. Good day and good evening wherever you may be. I thank you very much for taking out time to attend to this important and interesting webinar on changes and delay in construction industry in India. Well, let me first set out the agenda. The agenda will be, we will pose questions to our expert and curated panelists. After that, we will move on to answer questions that has been put forward to us by the audience. We have actually received numerous questions, and there is a facility in the portal itself. Please post your questions. We will endeavor and use our best effort to answer those. In case, because of paucity of time, we are unable to answer, we will ensure and we will try our best to write an email to you with our answers and views. Well, and I once again thank you for joining. After the webinar is done and complete, we will circulate a copy of the webinar to each one of you. Now, what is this webinar all about? You know, in India, changes and delays are very serious issues, and it is very frequent when delays occur. Now, because of the frequent delays, it causes a very serious economic loss. Now, changes arises because of intervening events, requirements of the contractor, requirement of the owner. Now, we have this eminent set of panelists, and I will introduce them to you for the purpose of giving an insight as to how to manage these risks with regard to changes and delay. We have with us Mr. Amba Prasad, Vice President and Head of Legal of L&T Construction. We have Mr. Ajay Kharbanda, Chief Legal Officer, North and West Sector and International Business of GMR Airports Limited, one of the leading airport infrastructure providers in the country. We have with us Mr. Venkat Ramana, Vice President, Contracts and Legal, Tata Projects Limited, India's leading project delivery company. And we have with us Mr. Rohit Singhal, who is the Managing Director of India, Singapore and Middle East of Masin Construction Claim Management Consultant. And I have my partner Raj Panchpatia, a legal expert, and he does a lot of work in the disputes practice of the firm, and he also does a lot of work in the construction sector. Now, let me, before I proceed with the questions, let me inform that I may be asking a question to one panelist, but any of you can join in whenever you feel like. Now, I'll start with you, Amba. Now, delay has various names in India, right? We have, why in India, across the globe? We have delays, we have concurrent delays, we have pacing delays, and there is no end, and we find out a new name when there is a delay, right? So I am asking you, what would a contractor do when there is a slippage in the construction program, and what would he do to stop the delay? Now, delay can happen because of your fault, because of owner's fault, because of anybody's fault. So what would a contractor do?
Thank you, Sudeep and Khaitan and team for having me for this webinar and then allowing me to share some of my experiences which I've gathered over a period of time in the construction contract and the issues relating to the performance of construction contract. As you rightly started, delay is there in every contract. I think today the scenario is that delay has become an inevitable component of a construction contract. Before the contract is being entered into, it is ideal that the employer and the contractor spend some time in analyzing as to what are the possible areas in which there could be a delay occurring and how can they really arrest that thing to happen. Now, it starts with the tender process. When the employer conceptualizes a project and tenders it out, he has to actually ensure that all the deliverables from his side are made available to the contractor so that there could be a seamless performance of the obligation of the contractor. At the same time, when the contractor reviews the tender information and prepares himself to perform the contract while submitting its code, in which the time is a given factor which contractor has no say about, he has to ensure that all information, all data that is required for the purpose of assessing that there won't be any issue with respect to the performance. And also, for that matter, all approvals, consents, and all such kind of things which are the owner's obligation are in place. So that the contractor's performance during the tenure of the contract goes in a very seamless and disruption-free manner. Nevertheless, there are issues with respect to delay that is going to be encountered. Now, the issue that we want to talk about is how the contractor is going to arrest the delay or prevent slippage. As and when the contractor comes to know during the course of his performance that the original program is now slipping and there has to be something done to arrest this slippage so that the performance can be complete in all respects within the given time and not incurring additional costs while arresting the slippage, he has to start informing the employer in a manner that has been agreed under the contract. Now, we all know there are various forms and substances of the contract available in the market. The employer chooses the best fit for it, actually, to let out the contract. It could be a FIDIC contract, it could be a bespoke contract, it could be a format contract, whatever that they are supposed to be there. The contractor has to be very much attuned to the requirements of the contract and perform its obligation of notification of each of these issues. Now, it's a matter of debate as to when the slippage occurs, when the contractor notifies the employer about the slippage, who becomes responsible to arrest the slippage. Effectively, it is a contractor who has to provide a preventive mechanism as to how this slippage can be arrested. But the arresting of the slippage comes with a cost. Who has to bear the cost? And how exactly it has to be apportioned in case if it is not going to be borne by both the parties. That are the things which are supposed to be dealt up in the format of the contract that needs to be seen into by the parties. Here, the involvement of the legal team of the contractor, whether it is in-house or external, becomes very critical. At which point in time, the legal team advises the contract performing agencies or the teams as to what are the do's and don'ts, what are the boundaries within which they can play, and exactly how are they going to really notify and start asserting the position with respect to the cause and effect of the delay and the responsible matrix with respect to the delay. There are issues where the contract clauses are ambiguous. There are issues where the contract clause is not clear with respect to recording of the event, but then the contractor is always under a bounded obligation to keep the
Yeah, Amma, thank you very much on this one. But let me also tell you, you have fairly conceded that it is the contractor's obligation to arrest the delay, which is a very fair thing to do. Now I move to you, Ajay. What would a owner do to protect himself from delay and a contractor's claim for to be excused for the delays? What would a owner do?
Thank you very much, Sudip. What one has to see is basically for ensuring that the contractor does not come out with a delay, it becomes incumbent upon the employer also to see whether it has designed the contract which is not which is immune to delays, or yes, there are certain circumstances which are unavoidable, and what all efforts it has taken to keep the matter within the assigned timelines. So for that, the proper planning by the employer also becomes very important before putting the contract to the bidding stage, and how well it has kept its employer requirements detailed out in the ITT. And basis that, if its planning is better, if it has done its homework better, it will come out with the KPIs which are achievable KPIs, keeping in regard, yes, exigencies. But still we know, while we have said that time is the essence of the contract, and employer has done everything to say that yes, contract must be completed within its timelines. Employer has taken into cognizance unavoidable delays as well. But delays are something which are equally challengeable and are the most frequent and most complex issues between the employer and contractor which emerge in any sector you see despite this. So what first employer must do when it must, after proper planning, develop the KPIs. Before award, it must have proper uh, briefing to all the bidders. So what it has to see, looking into the nature of the contract, where it is looking for the contractor, which type of contractors would be best suitable, and how they can achieve their timelines for the project. That becomes very important in the planning stage, because any delay will occur either because of situations which are beyond the control of any of the parties, or otherwise it is due to inadequate planning, or at the part of the contractor, inadequate deployment of resources, be it equipment, staff, labor, or raw material. So that planning, if employer does on its own, that helps. But still, if there are delays, then the ways are to provide for necessary provisions within the contract itself, which take care of mitigation measures. First and foremost, what employer must see to assess the risk matrix in the contract, and for which it must have, in a large contract, any risk assessment PMC must be available, deployed, who has devised the risk matrix. It will give us a paradigm of whether it is management related risk which can be and how they can be mitigated, whether there are risks associated with the contractor, how they have to be then taken care of in the contract itself. Then develop a good escalation reporting monitoring mechanism within the contract. What helps that frequent monitoring, catch-up plans with the contractor, and good staffing of the PMC who can give you the right feedback at the right time, acting between the contractor and between the employer, performing a role which is totally unbiased and in a very fair and transparent manner. That
Thank you,
helps a
Ajay.
lot in ensuring the contract and mitigating all those delays on the part of the employers.
Thank you, Ajay. It is good that you have suggested it is the owner's obligation also to do the planning and properly do the planning. Now I move on to you, Venkata. The question is, what should a contractor do to mitigate against owner's claim for delay, for damages for delay?
Okay. Thank you, Sudeep. Thanks for having me on this webinar, and good afternoon to all the participants in the webinar. That's a very interesting question, Sudeep. I think before I answer your question on what are the steps that a contractor has to take to mitigate the owner's damages, it's important that we know that 70 to 75% of all the construction law disputes pertain to delays. And it is also important for us to understand the concept of liquidated damages, whether liquidated damages are penalties, is there any cap on the limitation of liability that is there in the contract. These are the concepts we need to be very well aware of. And then the most contentious issue with respect to delays is the concurrent delay aspect. Of course, there are a lot of approaches how a concurrent delay has to be handled, and Mr. Rohit Singhal, who is my fellow panelist, will be able to elaborate on those aspects. But it is very important to understand concurrent delay is nothing but, if one event is within the control of the contractor and one is beyond the control of the contractor, how this delay has to be apportioned or how this has to be dealt with. So these are the aspects the delay analyst will look into to ascertain who has attributed to the delay, who has caused the delay, which will actually determine the rights and obligations of the parties, and also with regard to how owner's damages can be levied. So coming back to your question, how do you mitigate this? I think it all comes back to the basics. I think what is very important is proper record keeping. What I mean by record keeping is it is important to record the cause of the delay. This is very, very important. I remember a very important that, a few years back, almost a decade back, we were doing one of the hydel projects. There were unusual rains in that project. The project manager was so proactive, and he has kept the newspaper clippings of those unusual rains. He has kept the photographs of the project which is flooded, and he even had recorded an affidavit of one of the local farmer who said that he has never seen these kind of rains. Keeping a proper record and substantiating these delays is very important. It is one thing how these delays has affected the project. That delay analysis aspect is one thing. I'm sure Rohit will appreciate that a proper record and proper evidence which shows this cause of delay is very, very important, and it becomes a very important contemporaneous record when the arbitrators are deciding this dispute. Another issue we have seen is with regard to the seriousness and the timely maintenance of record at the project site. There are umpteen number of records that are being maintained at the project site, and these are typically in the form of monthly progress reports, minutes of the meetings. There are hindrance registers. These are maintained. These records are very, very vital, and it comes very handy at the time of preparation of delay analysis reports. And these records.
Thank you very much. Sorry for. We'll have to move on to the next question, and
Yeah.
I'm sorry for interrupting you.
No problem. I'll just conclude. I think it all comes back to basics. It is proper record keeping, and also recording the events in a contemporaneous time.
Thank you, Venkata, once again. Sorry for interrupting you. Rohit, now I move to you, because Venkata has already pointed a finger at you as to now you are responsible for answering that question. Now, there are many events of delay. Is there any specific priority of events which you take into consideration while evaluating the extension of time claim?
First of all, thank you, Sudeep, for giving me this opportunity to be part of this stellar panel. So, as Mr. Venkatramana said, how to mitigate a possible liquidated damages claim from the employer. That's the question. Now, under that, as he pointed out, the record keeping is definitely of essence. And honestly, we always say as claim consultants and experts in construction disputes, that fact is the king. Now, once you have numerous delays which are being alleged by both the parties, i.e. the employer and the contractor, the question comes is that all the delays have to be taken into consideration? The answer to that is no. So what both the parties have to understand is that there is a concept called critical delay concept. So when contractor alleges 100 delays onto the employer, or employer rebuts them by alleging another 100 delays onto the contractor, that is of no relevance until and unless both the parties come and find out which are the critical delays which are going to affect the project. When I say the word critical, it is from a concept of planning and scheduling, which means that a delay which affects the end date of the project is what is called as a critical delay. Now, there could be numerous delays which do not have any impact on the end date of the project because they have what we call as a float or a cushion in them. So therefore, if an issue or an activity has got 100 days of float, an activity can get delayed all the way to 99 days before becoming critical. So therefore, what we have to do is, first and foremost, is make a list of the delay issues which are intended to be pleaded by the contractor or intended to be countered by the employer. Find out which one of them are critical to the end date, and then do an analysis to see that which are the delays which are having the maximum impact on the end date of the project, and which amongst those critical delays impact the end date of the project. Is it employer attributable delays, or contractor attributable delays by way of undertaking a delay analysis.
No, but Rohit, don't you think the Walter Lilly case sorted this issue once and for all? If there is a relevant delay, contractor will get equivalent extension of time.
Not exactly. So, the Walter Lilly case does talk about critical delays. So it's not that any delay will entitle a contractor to extension.
It talks about relevant delays. Both will have to be relevant delays. Then contractor will get an extension.
The word relevant means critical delay. For example, I'll give you an example. Let's say if you are into a construction of a house and you have a possible delay in the drawings of doors and windows, which is probably attributable to the employer, but at that point of time, the roof of the house is under construction. So there is still a time which is available or float which is available for the contractor to receive that drawing, finalize the ordering of the doors and windows or fabrication of the doors and windows. So there is a cushion and a float which is available. So a delay in the drawing of doors and windows is not critical, but if there is a slow progress in the roof construction, that is critical.
Okay, Rohit, because of paucity of time, I'll have to stop you here because I want to ask you a very important question. No, we have seen there are various sorts of analysis that has been done, window analysis, as planned, as built, but for, and there are various analyses that are being done. What, according to you, is the best analysis? And also keep in mind concurrent delay cases. So what do you think is the best sort of analysis?
So, Sudeep, you hit the nail absolutely rightly. You see, there are various types of analysis which are prevalent in the market and as per the various protocols and guidelines of industry and all. First and foremost, there are two main methods of analysis. One is for prospective method of analysis. One is retrospective method of analysis. Under these two main categories of analysis comes the other categories of analysis, like you said, as built, as planned analysis, but for analysis, or time impact analysis and all. Now, a prospective type of analysis, one has to remember, favors a contractor. It doesn't favor the employer. A retrospective method of analysis favors the employer and is slightly averse to contractor. The reason is a prospective method of analysis is done when the project is under execution, not when the project is finished. The English meaning of the word prospective is looking forward, while the English meaning of word retrospective is looking back. So once the project is under execution, you generally do a prospective method of analysis to put the employer onto the notice that, Mr. Employer, I have a delay which is attributable to the employer is starting today. Therefore, I am entitled to an extension of time of X number of days, which is determined using prospective analysis. While in case you are into an arbitration or a dispute and you have done with your project, then you undertake what we call as the retrospective method of analysis, where as planned, as built analysis, the but for analysis, the collapsed analysis and all comes in. And of course, it depends upon what is the extent of data, what is the contract requirement, what is the legal requirement, which determines which method of analysis to be done. For determining concurrent delays also, there are specific methods, but again, a retrospective method is of.
So Rohit, I'll have to stop you here. It is getting very interesting, but because of the paucity of time, we'll have to progress. But we always deal with retrospective. When things come to us, things are over, right? Now I move on to you, Raj. Now, all construction contract, as Venkatramana has said, has this liquidated damages clause. Now, if there is a liquidated damages clause and there is a delay, pointing a finger at the contractor. Now, is it a matter of right for the owner to claim that liquidated damages, irrespective of what happens? Can you elaborate on this?
So, thank you, Sudeep, and thank you everyone for joining us today. And thank you for the panel for everyone to be there on the webinar today. As regards liquidated damages is concerned, I think the law in India is primarily based from the Sawpipe judgment and the judgment of Kailash, which kind of sets as to what the liquidated damages can be, what kind of liquidated damages can you claim, and when you can claim. Of course, liquidated damages is if you have already provided for in your contract a pre-estimate of damages, a genuine pre-estimate of damages, that is something the courts will definitely look at. But at the same time, the court will also see whether you actually suffered that loss or not. It is not just because it's provided for in your pre-estimate of genuine pre-estimate of damages, it's given. you are automatically going to get that. You still need to establish that there was a loss, and that genuine pre-estimate of damages was not in the nature of penalty. But there is a difference between a genuine pre-estimate of damages and the claims in the nature of penalty. Penalty is kind of an imposition for not doing the work in a particular manner, whereas genuine pre-estimate of damages is parties have agreed that this is the estimate, that this is the kind of loss that I'm likely to suffer if I do not complete the work in time as provided for in the contract. And that does not automatically mean that you will get the entire amount. You still have to establish that there is loss. And if you are able to do that, because generally we've seen in arbitrations that you will have to satisfy the tribunal that there was a loss, even if there was a pre-estimate of damages clause.
Thank you, Raj. Thank you very much. Now I move to you, Venkatramana. You see, we have now moved on from the topic of delay. Now we are going to the topic of change. Now there are changes and variations are inevitable in construction contract. Please tell us what are the sort of, when there is a change and variation in the work for which the contractor should get compensated. What are those changes and variations for which the contractor should get compensated?
I think fundamentally,
I mean the circumstances primarily. In what circumstances?
Yeah, I think fundamentally, we all know any instructions which depart the original tender conditions with respect to design, specification, or points constitute a variation. So what is very important here, of course, I don't want to dwell into the scope of a design EPC contract and scope of item rate contracts, because the variation, the definition of variation was very widely between these contracts. But before I think the most important aspect is one need to know is that any instruction that comes from an engineer is not a variation. The contractor should not assume it as a variation and go ahead with that work. I think very interestingly, the new form of contracts, the new protocol contemplates that as and when, I think it's also very important that we understand what are the limitations of an engineer in giving variation instructions. You need to see whether it is actually authorized to give such kind of variation instructions. These are very fundamental things to look in. But after he gives you the instructions, and I think the new protocol, rightly so, requires contractor to respond to that variation order and put up his case, and then if the engineer accepts it and there are proper written instructions arising out of this, then the contractor has to go ahead with the variation. I think it's important to know that sometimes most of the contractors actually welcome variation orders, because it is actually contractor is entitled for the cost plus overheads and profits that he's typically entitled to. And what is another very important thing, the dispute that typically arises is with regard to the valuation of variation. And there are various guidelines in which the valuation of variation has to be approached with. There are methods of valuation. If the quantity varies and it is of a similar work and there's already a price that is there in the contract, it is much more easier to approach these things. And if there is a similar character of work or adding a fair allowance, it can be approached. But if the variation is very complex, and I think most of the modern projects, especially in EPC contracts, where design is primarily done by the contractor, and then there are additional requirements of the contractor, and it gets to be a very complex scenario. So that's where we are. I think again it boils down to there should be a specific written instructions. You need to understand that on an oral instructions you act and you start claiming variations, that it would become very difficult. And these written instructions come from a person who is authorized to do it. This is another very important aspect. And with respect to valuations, I think what we need to look into is how do you value the methodology to be followed. That's it, Sudeep, from my side. I think I'm well within time this time.
Yeah, very much. Thank you very much. You see, Amba, now from a contractor's perspective, and I'll ask the same question to Ajay, what steps should be taken to minimize the risk of disputes arising out of change and variation? From a contractor's perspective, what should be done?
Thank you again. There are, again, I'll go back to the basics first. Type of contract matters a lot in such kind of scenarios. What is the role and responsibility of the contractor in a particular contract which is being performed assumes a lot of significance in arriving at how a change or a variation is dealt with. First and the foremost, I would like to take the example of an item rate contract, which is basically based on a BOQ based rates which have been given, and then whether it is remeasurable or otherwise, the contractor is being paid on the quantities that have been used. So in such a scenario, a contractor quotes based on the assessment as to how much quantity is required for the bills that have been made available, and then therefore there is a contract price arrived at. Now the changes arise during the course of execution of the works. As Venkat was telling, it could be due to contractor's requirement, or it could be due to sital requirement, or it could be due to owner's requirement. If it is a owner's requirement, I don't think we have any debate to make, because the owner instructs either directly or through the engineer that this has to be modified, and then therefore there is going to be a modification that is going to happen. But if the contractor were to encounter a situation which necessitates a change, and that change is absolutely essential to ensure that the works that the contractor is going to deliver is going to have its purpose served, without which it is not going to serve the purpose. The contractor will demonstrate that. Therefore, the cardinal principle of the contemporaneous maintained, appropriate notifications issued becomes very much relevant in the whole sequence of things. And in an item rate contract, it is also possible for the contractor to say that unless the changes are actually accepted, it would definitely not going to incur additional cost in this scenario, and probably can strike work for a time, and therefore pressurize the employer to come to a discussion and arrive at a kind of an agreement as to how this can be performed. Again, the point here is documentation becomes very much critical, and how exactly this change is going to be assessed and perceived by both the parties becomes very essential to arrive at a proper decision. Now, switching over to a different type of contract, which is not item rate, basically a design build or EPC lump sum turnkey contracts, where the design is also with the contractor, and the employer only has given an indication that I want a room, or I want a house with 5 rooms, then it is not the question as to how these changes are going to be pursued, because it is entirely in the jurisdiction of the contractor to propose what is the originally agreed scope, and then modification that may arise during the course of construction. Of course, if the employer wants a realignment of the system, then there is definitely a change of scope provision available. But in an EPC scenario also, it is a very clear drafting principle where it is clearly agreed that not more than 10% of the variations can be agreed between the parties. In which case, contractor is aware that he can at least be in a position to spend about 10% over and above the agreed contract price, not beyond that. If the threshold breaches, then the contractor can always say, I am not going to continue to work till there is a decision on this as to how this is going to be incurred and how it is going to be defrayed to me. Therefore, the changes within bracket scope change or variation can always be dealt with by the parties in a most congenial manner by recording it in appropriate manner and resolving the issues if there are any impasse. But more often than not, it doesn't happen. Therefore, we are all in the job.
Yeah, thank you, Amba. And you are also well within time this time. Thank you very much. Now I'll ask you the same question, Ajay. You see, what measures will you take to reduce the risk of disputes arising out of change from an owner's perspective? We have heard the contractors. We want to hear from an owner's perspective. What will you suggest?
Yes, Sudhir. Basically, change is also as equally vulnerable to the disputes as the delays. Hence, it is very necessary, as Amba said, that depending upon the nature of the contract, but I would say whether it's a item rate contract or EPC contract, what matters a lot is that how much how much you are giving to the hand of the contractor, or are you not allowing the contractor to go for a change without it being having been initiated by the employer. Generally, contractors are allowed to suggest the change, not implement the change, if certain conditions are met, like if it is adding to the efficiency of the project, it is providing valuation to the project, better valuation, or it is giving reduced cost to the project, then it is okay. Suggestions are welcome from the contractor. But when, because all contracts are designed to suit the requirements of the employer, it is always the employer who keeps this right available with him to whether some change has to occur or not. And change orders occur, as I said, that they are inevitable because there are a lot of dependencies. Despite good planning, you may have come across a situation which requires some change in the scope, resulting in the change order. So what matters a lot in these cases, when it becomes inevitable to do a change, how best you have described the process of the change order in the contract. That helps. And one must also see that it is not employer who has to hold the stick. It must give right opportunity to the contractor to seek all inputs, because ultimately it is the contractor who has to perform. So how well you have drafted the provisions in the agreement, how good you have given the opportunity to the contractor so that you understand the views, but employer always keeps the right within itself to ultimately decide on the terms of the change order and cost also. Even employer says that, okay, if there are disagreement on the cost between the contractor and the employer, but since work has to go on, keeping that aside, keeping certain benchmarks, employer also takes decision to get the contract, to get the even change order implemented. But what matters most, as Amas said, that it is both employer and contractor who have to come forward when it is the requirement of the employer to get the change order done. So fast decision making helps. There must be, employer must have certain internal escalation metrics to see to what level who can take decisions. If decisions are not being met, escalation 1 level. If there also escalation 2 level, then the time frame also, so that contractor also gets certainty to the change order, and employer is also at least comfortable that yes, if the change order is a must, it has to be issued, it is issued, it is implemented to the satisfaction of the both on terms of the time and in terms of the cost. So all depends upon how well you have drafted. In terms of the impact on the costing, again, it is required that it is not the package cost, but one must in the contract go into the detailed BOQ cost that helps in understanding and estimating the effect on the cost due to the change order, be it material, be it labor, or be it time related cost. Those can easily be assessed if the BOQ is well crafted and made part of the contract besides the package cost.
Thank you very much, Ajay. Thank you very much, Ajay. Now I move on to you, Rohit. How should changes and extra work be evaluated?
Yeah. So Sudeep, again, it depends upon the provisions of the contract. A lot of time, contract has a clear stipulation that how a possible change order or a variation is going to.
I'm also asking to mention, if nothing is mentioned in the contract, if an extra work is so out of, so if you please cover that also. Thank you.
So there are two scenarios. One is if the contract has a stipulation that how a change order has to be valued. Generally, in majority of the contracts, what is given is the first and foremost is you try to use the rates which are specified in the contract. If it is an item rate contract, you have the BOQ rates, which are really helpful in evaluating and valuing a change. In case it is a lump sum EPC kind of a contract, then of course it becomes difficult. So in that situation, if it is a lump sum EPC kind of a contract, then of course what you have to do is, as a contractor, you have to see what is the actual cost which has been spent on that change. So you have to calculate the material takeoff related to that change, how many engineering hours have been spent, how many civil related resources have been spent, how many other resources have been expanded, material cost and all that. and based on that you calculate the actual cost against those, add on top of it the overhead and profit of the contractor, and then you submit the change order or the value that whatever is the claim to the employer. And in the event the contract has no guideline how to value a change, then also a contractor is required to value the change as per its actual cost expanded, and on top of it add some reasonable overhead and profit in order to value the change order. So that's generally the concept which is accepted in the arbitration panels as well, by the arbitration panels and also by the employers. The first and foremost is actual loss which has been suffered by the contractor because of that change has to be claimed.
Rohit, you are saying that it is because of the fact that contractors perform this change obligation, correct? It's post-performance.
Yeah, so let's say even if it is you have been instructed a change by the employer, then in that case, and there is no clear guideline on the valuation of that change, so then also you will have to spend, you will have to calculate what is the actual cost which you are going to expand in undertaking that change order, and add on top of it the overhead and profit. Once you have done the change and you have executed the change order, then also in case the contract provisions are not giving you any assistance, then also the actual loss has to be claimed.
Thank you very much. I have many more questions, but I would like to, at this stage, move on to audience's questions. There is a because we are on the topic of change, this question has come from Mr. Vikas Kumar, Senior Quality Surveyor, Voltus Limited. Most of the construction contract, I will pose this question to you, Amba, because we are, and maybe any of you can jump in. Most of the construction contracts require the contractor to proceed with the work on issuance of formal instructions. However, at a later stage, when the works are completed, the entitlements are rejected, leading to disputes. How to avoid this situation? Amba?
This is a often repeated situation in many contracts. The contract goes on a premise of good faith, and the contractor performs these instructions with an anticipation that all these oral instructions or informal instructions get formalized during the course of performance or at least somewhere before the completion. And therefore, he will expect that at the time of final bill, perhaps all these additional works and so-called variations which have not been instructed will get included into the final bill and then submitted. At that point in time, when the product has been delivered to the employer, it is always a case that the employer will actually make a U-turn saying that no, it is the job you are supposed to do. Therefore, there is nothing additional in this. Therefore, take a walk. So in these scenarios, it is essential that the contractor records the conversations or informal instructions by way of a writing or a communication issue to the employer and the engineer saying that these are the instructions that have been given to him for carrying out certain modifications or alterations or deletions. And this is the time or cost impact with respect to that. And contractor is going to follow this up to its logical conclusions as to the provisions of the contract. There should not be any slippage in terms of these notifications. And also it happens that many contract managers, in the garb of relationship, I don't want to hurt him, I want to just keep in good side of him, I would not record it anyway, he has told that he will take care of it in the next bill or whatever it is, they will never record such kind of situations. So they also will have such kind of a contractor will, after spending the money, will start running to the employer for the additional payment.
Abba, I'll come back to this point once again if we have time. But Raj, I move on to you. This question has come from Viswas B, Senior VP, Projects Control and Contracts Admin, Kalpataru Limited. Most of the contracts don't elaborate payment delay impact. Can the contractor vendor suspend work contractually legally owing to the delayed non-payments from other parties?
It's an interesting question because unlike in UK or in Australia, there are legislations which allow you to do that, but in India there is none. So in India, if you feel that you don't want to continue with the work because you're not getting paid is not only a decision which is commercial in nature, but it's something that has to be done very thinking it through, because these are long-term contracts that you enter between employers and the contractors, and you want to ensure that you are going to be in this contract for a long time. Do you really want to not continue to work because your payments have not come, or would you want to put the contractors, whether the contractors would want to put an employer in on notice? Because there are sometimes also situations where there are reciprocal obligations. Now, there could be an employer's obligation and then there is a contractor's obligation. Now, if the contractor obligation is to continue certain work, but for which it requires payments, and if the payments are not going to come from the employer, then his entire subsequent chain of work can get stalled. So it has to be also kept that in mind. Some of the contracts also provide that irrespective of the dispute in relation to the payments, whether the payments have come or not come, if there is a delay or not, the contractor is bound to continue to complete its work, and in the forthcoming dispute and arbitration, he may make the claim for it. So therefore, while making such claims, commercial understanding between the parties is very important. It is very important parties sit together and resolve this at that point in time, rather than letting it escalate to a level that you have to stop the work because of non-payment. I think that is very, very critical.
Thank you, Raj. Now, this question has come. This question is for you, Venkata. This question has come from Mr. Satish Reddy, contracts manager, and in fact, it has come from Tata Projects Limited. Why most of the construction projects in India get delayed even after proper planning? And after you say, maybe I'll also take inputs from Ajay on this. Yeah.
Okay, I think it's a very, very interesting question. All the infrastructure projects across the globe, there is always a time and cost overrun. But what is very important is there is a Ministry of Statistics and Program Implementation of Government of India. It monitors all the projects which are above 150 crores. Okay, so there are about 1700 projects that it is monitoring. And out of these 1700 projects, about 800 projects are into time and cost overrun. And what is very interesting is that you need to look into what are the causes of this cost and time overruns. It is not because of lack of planning or lack of execution capabilities or technology capabilities. And most of the causes are geopolitical reasons. Like, for example, I think some of the delay attributes are delay in land acquisition, delay in environment and forest clearances, funding constraints. Of course, this is not something which is I have seen for the first time. Funding constraint is the reason in government projects. Rehabilitation and resettlement issues, and local body municipal permissions, utility shifting, and contractual issues. These are the reasons they say that they are attributable to the delay of these 800 odd projects out of these 1700 projects that the government of India is monitoring. These reasons, if you see, are very, very specific to the India, and this requires substantial thinking from the policy administrators and the way the contracts have to be awarded and what stage it has to be awarded. What are the pre-requirements like land acquisition and environmental clearances are to be in place before tendering all these contracts. I think this is something that the government has to address. Of course, there are always delays attributable to other aspects.
I'll come to you, but Ajay, will you give your inputs on this also? What do you think? Very briefly. You're on mute, Ajay, it seems. You're on mute, Ajay.
Yes, I agree with Venkat. Whenever you do a proper planning, you try to take care of all maximum unforeseeable causes as well. But India is such a peculiar country where, despite this, there are certain events which you cannot foresee, and which are even foreseeable. Their causes, their effects go beyond what you have imagined. And as a result, it is all because of either force majeure causes. Generally, these are the force majeure causes. Could be if a project is highly dependent on imports, if there are issues on that side which cause a delay, or local reasons, environmental reasons, they come into the play of making the projects delayed. Financing has, yes, very recently we have seen, but side by side we have also seen how proper planning has helped in not only timely but earlier than timely execution of the projects. I would say that one must review all aspects before commencement of the project. I would give you an example of this Delhi airport. Once it was awarded, such a mammoth infrastructure could be completed in 37 months. Means it's a record achievement in itself. What led to achievement of it, despite challenges, unforeseeable, foreseeable, is the commitment and I would say proactive planning, proactive approach, and thoughtful planning, which always helps. We have seen even in daily DMRC projects how they are getting not only timely, earlier than time completion. So all depends on the, I would say, force majeure conditions and how well you are able to mitigate
that. Mr. Sudeep, you are on mute.
Amba, you wanted to add something to this?
No, I just want to allude to what Venkat and of course later on even Ajay was telling, that these delays are not typical to India. Employer delays are their global phenomena. I think we have seen it in Middle East. The employer delays causing a lot of project suffering in terms of time, therefore cost. So it is not typical to India. Therefore, we should not really be, castigating our country in that regard. Second point is, I just want to say what Ajay said with respect to the completion, timely completion. Yes, if the owners are passionate about completing the project and the contractor can measure up to the deliverable within the time and scale what they can, it can be done. Delhi was one example. We have the Statue of Unity to give another example. Commonwealth Games that was done in record time was all examples to see, but then they are not getting replicated elsewhere. I don't know why and how.
Thank you, Ajay. I will thank you, Amba. I will take one question myself. This says this has come from Niranjan Rai of Boeing. Are there instances where courts and arbitrators have refused to enforce the provisions of a contract on the basis that the terms are too one-sided in favor of the employer and unfairly stacked against contractor, subcontractor, or standard form that has not been properly negotiated? Mr. Niranjan Raj, let me tell you, there is a principle called contra preferentum, and if a contract is drafted in a one-sided manner, it will always be held. If there is an interpretation issue, it will be held against the draftsman. So we can share the case laws and other things with you later. But now I move on to you, Raj. Now, we really do not have the time to take any more questions, but I assure you, all the questions that has come to us, we will make our best effort to answer, send you an answer over email, and maybe we will ask our panelists to contribute also wherever there is a requirement. Raj, can you please sum up this entire webinar and say what are the 3 takeaways from this in terms of managing risk for changes and delays in construction industry?
Thank you, Sudeep. Thank you all of you for giving your insights on the construction industry as leaders in the construction industry and the field of construction industry. And correct me if I go wrong anywhere, please. From the discussions that we've had today, I thought that there were 3 critical buckets that we need to keep in mind. One was at the time of drafting of the contract itself, to ensure that we provide for all necessary requirements within the contract itself, so we don't keep things vague and ambiguous. Maybe if we have to provide for obligations of parties, we provide for them in the contract itself, so the parties are clear as to whose obligation is what. Say for instance, there are government approvals that are required to be taken. It will be whose responsibility to take the government approvals. If there is a change order requirement, if there is a change order has to be brought in, how the change order, who will initiate the change order, how it will be compensated, for the work, the additional work that was required to be done because of the change order, provide for in the contract so that tomorrow when it goes ahead, there is no dispute or litigation that arises out of it. How would you compute liquidated damages? Are you providing for pre-estimated damages, pre-estimate of damages? Is there a mechanism? Is there a formula that you want to adapt? Is there a Hudson formula? Is there any other formula that you would want to adapt? Provide for it in your contract. Also provide for something like say site conditions. If the site conditions have been looked at by the contractor, if it's for the employer, or did you have the right to look at the site condition at the beginning of the contract? So maybe first critical bucket is to drafting of the contract. The second critical bucket to my mind was proper planning of the contract, and that was the second takeaway for me. I think it's a proper planning, constant monitoring, ensuring that there are suitable levels of escalation where as and when it is necessary to escalate an issue and troubleshoot the issue there and then, rather than let it escalate to a level that it goes into disputes and it has to eventually end up in an arbitration and the claims are there against each other. So to my mind, a proper monitoring, effective monitoring and constant supervision of the project is very critical. That's a second takeaway to my mind. And the third, of course, is a proper maintaining of the documentation, because most of the infrastructure projects that we've seen do land up in litigation. And this sounds cynical, but that is we've seen that most of the disputes go some kind of arbitration.
I must stop you now because we are running out of time. Now, before I give my vote of thanks, I would request each of the audiences, if you can look at the poll slide and give your comments on the webinar itself. We take this very seriously as a part of our development program. Having said that, let me now thank you, Amba, Ajay, all my guests, Amba, Ajay, Rohit, and Venkat, for being with us today, sharing your inputs and sharing your valuable inputs. This webinar would not have been possible without all of you being here, and we are grateful to you. We are also grateful to the audience for taking out time to attend to this webinar. If you have any questions, please reach out to us. Our contact details are provided, and we hopefully will have future webinars and we'll be able to be of service to you and bring similar webinars like this to you. Thank you very much.
Thank you.
Thank you.
Thank you.